Hello, and thank you for wanting to view this presentation on the dangers that lurk in specialty line insurance policies. Specialty line insurance policies are usually those that cover director and officers, employment practice policies, cyber protection policies, as well as error and omission and professional liability insurance policies. What is common and unique about all of these insurance policies is that they're normally written on what's called a claims-made basis. Further, the claims-made policy itself has evolved over the years. It first became available sometime in the 1950s and allegedly was originally authored by a gentleman by the name of Victor O. Schinnerer. Some others seem to think that Joe D'Alessandro, who later became president of National Union Insurance Company, may have originated the policy for medical malpractice exposures when he was a young underwriter at St. Paul Insurance Company. Whether or not it was originated in the 1950s or 1960s, the policy has evolved over the years, and now the most common type of specialty line policy written on a claims-made basis is the policy known as a claims-made and reported form. Dangers and gotchas lurk throughout the policies. But first, let's discuss some generalities with respect to this industry. Some might say that insurance is one of the most intangible products that exists on the planet, other than maybe Bitcoin today. But how are these products and services designed and developed? First, begin with an assumption that you can see on the screen. The first assumption is that the product sold to a policyholder really is nothing more than how an insurance company responds when a claim is submitted to them. How will that insurance company react? Is it going to become belligerent and adverse with their own policyholder, or are they going to live up to what is called reasonable expectation? Assume also that actuaries, in desiring to set the pricing, they certainly use historical data and do other research to determine what may be a pricing mechanism that is going to work and return a profit for the insurance company, but they do miss an important factor, which we're going to get to in a moment. Finally, of course, does the product meet the reasonable expectation of the insured? And does it live up to the reasonable expectation? Now, we all know that policyholders often have unreasonable expectations as to insurance. The most frequently heard one is that he thought, or they thought, they were covered for everything, or they would never have to worry about a claim being denied, what have you. And unfortunately, that product doesn't exist, will never exist, and is impossible for it to exist. There are certain things that are uninsurable. There are certain events that are unanticipated. And of course, when it comes to limits, no matter how high somebody may buy limits, there's always a possibility that a claim could take place that actually would be a loss higher than the highest limit they thought they could get and afford. So what is this product really about? Well, if the product is how the insurer responds, then living up to the policyholder's reasonable expectation will eliminate uncertainty. When you eliminate uncertainty, it increases the probability of a profit for the underwriter. Profit thus becomes a result rather than the original goal. So really, how does this work in the real world? Well, consider this. If a policy is so poorly written or is filled with gotchas and hidden secret ways for an insurance company to deny coverage, what's going to happen is the insurance company is going to sue the insured. And of course, for what's called a declaratory relief lawsuit, seeking a judicial determination that the policy does not cover the claim that's been submitted. Of course, that means that the insured is going to get a little ticked off and file his own cross-complaint for bad faith in breach of contract, or maybe he initiated that lawsuit and now the insurance company is cross-complaining for a declaratory relief. Either way, that's two lawsuits. In addition, the policyholder may also sue their insurance broker in the alternative, simply because you both can't be right. One of you's got to be wrong. The insurance broker told me I'd be properly covered. The insurance company says I'm not. One of you's got to be wrong. And of course, finally, you've got all the expenses that are incurred from this litigation that was shouldn't be necessary and further was unanticipated. The problem is the declaratory relief lawsuit and the bad faith lawsuit being defended by the insurance company, those give rise to expenses commonly referred to as unallocated loss adjustment expense. ULAE is how it's commonly referred to. Well, you remember when we were discussing actuaries and how they review historical losses in order to determine pricing, etc.? Well, one of the things they do not usually use in their actuarial analysis is ULAE. They do not include in their actuarial analysis the costs associated when the insurance company is suing its insured for declaratory relief and defending itself from a bad faith case. So if an insurance company is constantly suing policyholders saying, we don't cover you, and drawing cross complaints saying, yeah, you do, guess what? They can't passively make money. It's not included in the actuarial model. And if it's not in the actuarial model, they can't make a profit. In addition, of course, the insurance broker is getting named. The insurance broker may be a party to the litigation. So in essence, you've got the actuarially anticipated claim against the insured giving rise to 3 other unanticipated lawsuits. It's actuarially unsustainable. An insurance company can't make money doing that. And as a result, by creating unreasonable expectations, by filing these lawsuits and having all this uncertainty in these policy forms, it increases the probability that the insurance company is not going to make money. Whereas if we can eliminate these uncertainties and live up to the reasonable expectation of a policyholder, then the uncertainties are eliminated. The insurance company is acting within the actuarial model and thus making a profit, which is good for everybody. After all, this does lead to market stability. The insurance carrier stays in the marketplace with this kind of coverage. The broker's got a stable market, and the insured has a product that lives up to their reasonable expectation and will respond as they would have expected an insurance company to respond. Now, isn't that good for everyone? So let's get into a basic insuring agreement that we have seen for years in the specialty line insurance industry. This is a basic insuring agreement that we see frequently. This policy is written on a claims made and reported basis. It covers claims which occur subsequent to the retro date and are first made against you, the insured, and reported to us, the insurance company, while the policy is in force. No coverage exists for claims reported to the insurance company after the end of the policy unless, and to the extent, an extended reporting period applies. In other words, the claim must be first made against you during the policy term, and you got to tell the insurance company about it during the policy term. And the reason this language has come about over the years is because a lot of policyholders were getting lawsuits in. The policy did not require the claim be reported during the policy term, at least not in the insuring agreement. And a lot of policyholders didn't timely report their claims, sometimes long after the policy expired. And in order for an insurance company to deny coverage and claim, gee, you didn't tell us about this in a timely fashion, the insurance company had to prove that they were prejudiced by the late reporting, and that, as a result, a different result might likely to have occurred. Well, when they started using this language sometime in the late 1980s, early 1990s, and required that the claim be reported to the company during the policy term, that language has since been ruled to be enforceable, and that the prejudice is no longer required, just that they insured didn't report the claim as required by the policy and the contract. So what about this language? Unless and to the extent an extended reporting period applies. This is a gotcha, because as this language shows, the claim must be reported during the policy term. Well, what if there's no time to do so? Believe it or not, the most difficult or most dangerous time for a policyholder is at or around renewal. And keep that in mind throughout this entire presentation. The most dangerous time for an insured is at or around renewal. So, what happens if the insured is served in the parking lot on Friday afternoon and and that's the day of his renewal? Is he really going to be able to report that claim before midnight to underwriters at Lloyd's? Or he's sick, or he's out of town, or he's on vacation, Will his office staff know what to do when a lawsuit arrives or when a demand letter arrives, or will they have even opened it? That's the problem, because it is possible for an insured to have a good faith reason as to why he wasn't able to report the claim before the policy expired. So what about this extended reporting period? Does that give the insured extra time beyond the expiration of the policy to report a claim when being a little bit late is actually in good faith? Well, let's look. Let's see what that language might be. Here's an extended reporting period, language that we see frequently. In the event of cancellation or non-renewal of this policy. And then it goes on to say there's an automatic extended reporting period. Coverage as provided under this policy shall automatically continue for a period of 60 days. So there's basically a 60-day grace period. Well, that's nice. But this language only applies in the event of cancellation or non-renewal. What if the insured renews? Here's another insuring agreement, and by the way, as you can see, it simply requires that the claim be first made against the insured, be reported in writing to the insurance company during the policy period. It doesn't even refer to an extended reporting provision. So with this language, it's possible that the window slams at midnight, and under no circumstance will the carrier consider a claim that is reported to them after the policy expires, no matter how good the excuse may be. Now, this could have been good language. You can see up here where it's all in caps, the common preamble that we often see on the deck page of an insurance policy. And then we have in the insuring agreement, again, the language that they will pay as a result of claims first made against the insured during the policy period and reported to the company in writing during the policy period, or within the 60-day automatic extended reporting period. In other words, this policy appears to give a 60-day grace period beyond the expiration of the policy to report a claim that deals with the good faith problem of being served in the parking lot or being on vacation or being ill. And remember, what if the lawsuit was filed 45 days before the end of the policy and not served until right beforehand? Then you got only 15 days to answer, and you've got the 60-day automatic extended reporting period. Well, let's take a look at this 60-day automatic extended reporting period. And guess what we found? The 60-day automatic extended reporting period, the AERP, is great, but it's not mentioned anywhere in the policy. There is an automatic extended reporting period. There isn't any. There's a basic extended reporting provision. But here again, it's limited to when the policy is canceled or non-renewed, or when the policy is replaced with a policy that has a retro date later than the one shown on the declaration page of the expiring policy. That's kind of weird. Why would that happen? Nevertheless, there is no automatic extended reporting period. There's a basic extended reporting period. So the language we saw on the previous slide doesn't even exist. So is it applicable? Who knows? So isn't the language down here even better? That this policy will pay arising from any claim first made against the insured and reported to the insurer in writing during the policy period or within 60 days thereafter for any actual or alleged wrongful act? Isn't that better language? It's not tied to an extended reporting provision. And remember, the extended reporting provisions we've seen only apply when the policy is canceled or non-renewed. What if the insured renews? Does the insured then have 60 days to report a claim after the extended reporting provision? It's not mentioned in the insuring agreement unless it has the language that we see on screen right now. This one does, but not everyone does. And if it's not in the insuring agreement, what happens then? And it seems kind of odd to me that an insurance company would give an insured they're canceling for whatever reason more time to report a claim than would give a loyal insured who's staying with them and renewing. The same is true of, the same thing if the insured decides not to renew. I mean, I like the fact that the extended reporting provision is bilateral. Nevertheless, what if the insured decides to move to a different carrier? You're still giving that policyholder more rights to report a claim beyond the expiration of the policy than you're giving a loyal insured who's staying with you. I don't understand that logic. Nevertheless, if we go to the next slide, here's a danger, another danger. And keep in mind, all these provisions are read by a court and interpreted accordingly. Bear in mind, too, one of the things we said earlier in this presentation, and that is the most dangerous time for an insured is at or around renewal. So, with that in mind, here's some definitions of the word claim as they exist in many policies that I've reviewed over the years. And these are all current forms. Claim means a written demand for monetary damages arising out of or resulting from the performing or failure to perform professional services. Here's another definition of claim. Claim means a written demand for loss or non-monetary relief against an insured because of a wrongful act, or any lawsuit or any suit, as this one says. Okay. Maybe you're seeing a danger here, but we'll continue. Here's another definition. Claim means a demand for money or compensation for a wrongful act, any judicial or administrative proceeding, including a disciplinary proceeding, etc. We have another one that includes the request to toll the statute of limitations relating to a potential claim. And then, of course, you might even have, we've seen them where they say the service of a subpoena to produce your file could be, quote, a claim, end quote. Well, the problem is, maybe you've already guessed it, but I think it's certainly down here in the parentheses, is this language there? Is a claim considered first made when any insured or insured's legal representative receives these things, these various demands or lawsuits or judicial proceedings? Is that language present or not? And I can guarantee you there are numerous policies that do not require in the definition of claim that the insured has received the demand letter, that he's been served with a lawsuit, or that the insured knows about the judicial or administrative proceeding. Well, the point is, if the insured hasn't received it, how can you report something to an insurance company you don't know about? The point is, the policy's been triggered by an event that the insured knows nothing about. And if it's at or around renewal, the insured may not know about the fact his policy's been triggered until after the policy expires. In which case, does he have any automatic time to report a claim? This is real. These types of things have occurred many, many times, and there are a lot of insurance policies whose definition of claim does not require that the insured has received the lawsuit or notice. And that is something that you as professionals out there, or buyers or consumers, need to know about. Oh, it gets better. These aren't the only gotchas that exist in claims-made forms. There's also usually in almost every insurance policy a condition section, and gotchas regarding claims-made triggers can exist in those as well. And remember, this presentation deals with gotchas that are common to almost all claims-made policies. I mean, after all, if you can't trigger the policy, what difference does it make whether the hazard being insured is director and officer liability, professional liability, employment practice liability, or cyber liability? If you can't trigger it, it doesn't really matter, does it? So here's some more gotchas that can exist with regard to reporting requirements. Typically, in the condition section, there'll be this language, a condition reporting of claims and potential claims. And here's the language. The insured, as a condition precedent under this policy, will give written notice to the company as soon as possible or as soon as practicable. We've seen that language too. Within the policy period or during the policy period of any claim made against the insured. The company agrees that the insured may have up to 60 days after expiration to report that claim. Now, the problem with this language, as good as it sounds, is what if it's not referred to in the insuring agreement? The insuring agreement says a claim must be first made and reported to the company during the policy term or in accordance with any extended reporting provision. The extended reporting provision says it only applies in the event of cancellation or non-renewal, then the insured shall have an additional 60 days. Here we have a condition that makes it look as if it does give 60 days irrespective of cancellation or non-renewal, but it's not referred to in the insuring agreement. And I have seen and experienced claims being denied because the coverage attorney for the insurance company says, well, yes, I know that language is there, but it's not referred to in the insuring agreement, so we don't know why it's there. We just know that this is what the insuring agreement says. The insured didn't comply, and we're going to deny coverage and sue the insured for declaratory relief. Wow. Remember what we said earlier? Unnecessary litigation, acting outside the actuarial model. These things have actually taken place. Now, another problem is what I call the time bomb. We know that these policies are claims made. We know that there's a requirement to report the claim during the policy term. That could be 6 months, 9 months, a year down the road before the policy expires. But some policies have an internal time bomb requiring that once you know about a claim, once you've been served, or once you have received a notice, you've got to report that within 30 days. So it's not really a claims made and reported form. It's a claims made and reported in 30 days form, or 60 days. And I've even seen it go as far as 90. But nevertheless, that's pretty strict language, and it is probably legally enforceable. So there's a ticking time bomb from once the insured knows about it to report that claim. Take these things seriously. They're being enforced all over the United States. In addition, there's something else that many people don't realize. Just about every insurance claims-made policy written has what's called an incident reporting provision or a potential claim reporting provision, and that's different than a claim. A claim is an actual demand or the service of a lawsuit or whatever. What happens if one of your employees comes to you and says, gee, we screwed up, or here's what I did wrong, and we may get sued one day? Well, that's something that could be a potential claim. And if you report that before the expiration of the policy, and usually there's some conditions, you got to be specific. There's like 5 different things that you usually have to tell the insurance company, because the insurance company doesn't want a laundry list saying, oh, here's all the transactions I did last year and over the last 10 years, and I might get sued someday because of them. They're not going to allow you to do that. So they've come up with these specifics that you may have to satisfy in order to trigger the policy, even though no formal matter has taken place. Nobody's threatened you, no lawsuit's been filed yet, etc. Usually what happens is if you do comply with these 5 items that are here by giving specific information regarding the act or alleged omission, the dates and persons involved, etc. If you do provide all this information, usually the insurance company will send you a letter of acknowledgement and say that the policy's been triggered, and if anything further takes place, to let them know promptly. And I do underscore again, promptly. One thing you need to know about an incident reporting provision: the incident must be reported prior to the expiration of the policy in sufficient detail. There is usually, and I've rarely seen it, I think there was only one policy form I've ever seen that did give it a little extra time to report an incident. Usually, if you do have any extra time, that applies to actual claims only, to report a claim after the expiration of the policy. Incidents must be reported before expiration. I've only seen one policy that did give a little extra time. So be careful with that. Make sure if you're a broker, that your policyholders are aware of that. Incident reporting time bomb. I've seen a few policies where once you know about a potential claim, you only have 30 days to report it. So you don't have until the end of the policy term. As soon as one of your employees says, gee, I screwed up, we may get sued one day. No, sorry, you only have 30 days to report that to the insurance company. And if you recall from the prior slide, one of the items they're going to want to know is, when did you first learn about this problem? If it's more than 30 days ago, guess what? They're not going to honor the incident reporting period. So again, here's a time bomb and a gotcha that is very rare. There's only a handful of policies that have this language. So we got your attention now on the potential gotchas in the claims-made form, because we've only scratched the surface. One of the biggest problems that exist today are the usage of what are called absolute exclusions. Now, usually insurance policies, of course, have lots of exclusions for any number of reasons, but they generally fall into 4 categories. First, there are exclusions for things that are just uninsurable because they're moral hazards or they're against the public policy of the state, or they're just, you can't insure for intentional or illegal acts, for instance. Such things as having to give up your returned fees, like if an attorney's being sued and being asked to return the lawyer fees paid them, those are not insurable. Under employment practice policies, you can't get coverage for the wages you owe somebody. You may have to pay the damages for not paying appropriate wages, but you still got to pay the wages yourself. Again, that's a morals hazard, and you can't cover them. There may be certain types of claims against specific hazards that are uninsurable, or the insurance company just doesn't want to cover them. For instance, any SEC violations that may exist in or a corporation that is not even publicly traded. They're privately held. And it's possible to buy those exclusions back, but sometimes some D&O policies just, won't cover security violations when a corporation is privately held. So that's another category of exclusions. Another category of exclusions, of course, is because there are other policies to cover that. For instance, in almost every type of liability policy imaginable on the planet, there's a workers' compensation exclusion, except in a workers' comp policy. You'll also find exclusions for discrimination and sexual harassment, etc., unless it's an employment practice policy. And I think you understand now that, pollution is another thing that you're going to find in almost every policy, except a pollution liability or contractor's policy as well. But in essence, if there's other coverage policies available, then you're going to find that those types of things will be excluded in the particular form. The danger is whether or not the exclusion is worded in such a way as to go beyond the policyholder's own actions and refer to what's called the underlying matter. And the problem with absolute exclusions is that it uses the following language: any claim based upon or arising out of, in whole or in part, directly or indirectly. There have been cases all over the United States that says the language arising out of means connected with. So here's an example of an absolute exclusion. One deals with discrimination, etc., and the other one deals indirectly sexual harassment or coercion. Okay, fine. So you're an attorney and you're representing somebody in a sexual harassment case, or maybe you're defending a sexual harassment case. Are you covered if you get sued for malpractice? Because here's the language: based upon, arising out of, directly or indirectly. Or maybe you're an insurance broker who's selling employment practice liability insurance to clients, and in your E&O policy it has this language. I don't see anything that refers to the insured. I don't see anything that refers to the insured's wrongful act, which can only be committed by an insured. And I don't see any carve-back that says this exclusion won't apply where the insured is providing professional services as an attorney or insurance broker, what have you. So are you covered? And there have been cases around the United States that have held, well, no, you're not. And we'll get to some of those in a moment. Here's one. These are some examples. The company is not liable for damages rising out of, directly or indirectly, pollutants, whether or not an insured caused or contributed to the pollution. Wow. So that goes back to what I was saying a moment ago. If you're an attorney defending a pollution-related case, or you're an insurance broker selling pollution liability coverage or environmental coverages, well, you might not be covered with this language. There are carve-backs based upon directly or indirectly arising out of the insured. Well, any absolute exclusion that refers to the insured or refers to a wrongful act that only the insured can commit, then I don't have a problem with it, because really all it is then is basically saying, if you're worried about pollution, go buy a policy for yourself. But this language up here, there's no carve-back. So here's one. Here's another carve-back. This exclusion should not apply brought against any insured for failure for the insured place, effect, or renew any insurance. So this is the kind of carback I'd expect to see if you're an insurance broker. Obviously, if you're an attorney or an architect or whatever, it would be worded a little bit differently, but this is a carback. Now, what do you do with respect to a carback that only refers to certain absolute exclusions like E, F, I, M, and U? Those exclusions will not apply because of your alleged or failure. Fine, but what about exclusion A, B, C, D, G, H, etc.? That tells me that the insurance company intends to enforce that exclusion whether or not an insured caused or contributed to the problem, even though the language may not even be there that I'm circling, even though this red language may not be there. If you've got a carback that only refers to certain exclusions, what about the others? I've also seen policies where there's a mix of exclusions. Yes, they all use absolute language, rising out, based upon, arising out of directly or indirectly, but some of the exclusions refer to the insured. Some of the exclusions use the language arising from a wrongful act. Some of the exclusions may have a carback, and other exclusions don't. So the ones that don't, there again, it seems to me that a court would say the intent of the policy is clear, that whether or not an insured caused or contributed to the problem doesn't matter. It's still connected with, and the exclusion will be upheld. Wow, that's pretty wild. And I'll tell you give you another example of a case that's going on right now. United National Insurance Company. They're an insurance company. They write environmental liability insurance amongst a lot of other things. Like many insurance companies, they buy insurance company E&O insurance for themselves. And what that does is cover them for bad faith lawsuits and bad faith damages in the event they wrongfully deny coverage on a claim. In filling out an application for their E&O coverage, they had to list out all the lines of business they write, how much premium volume they wrote, and of course I have to believe that that was part of the rating factor for setting the premium rate on their errors and omissions policy. This was a multi-million-dollar policy. It had $1 million plus deductible. United National denied coverage on 3 different environmental liability claims, got sued for bad faith on all 3, tendered to their E&O carrier on a timely basis, and guess what? The carrier denied coverage because they had an absolute exclusion for pollution and an absolute exclusion for environmental claims. And it did not have any carvebacks. The insurance company had filed a motion for summary judgment, which was granted, and now the matter's up on appeal. Everything I'm saying in this presentation has already happened. It is not academic. These claims are real. So let's talk about let's talk about ERPs. There are more gotchas. As you know, extended reporting provisions are very important. And what they really are is like retirement coverage. Like if you decide to retire, you can always be sued tomorrow for something you did yesterday, so to speak. And so how do you protect yourself? Well, you buy an extended reporting provision, also known as tail coverage. Of course, you must give written notice so that you want to do that, and you've got to pay the entire premium very timely, and it's fully earned, and et cetera. But here's a gotcha. Often we've seen on the declaration page or in the actual condition language what the premium will be. But there are a handful of insurance policies out there that don't. And in this one it says, with the written notice, the applicable premium will be calculated in accordance with the rates and rules in effect on the inception date of the policy. We don't even know what they are. Or sometimes it just says, language to the effect that the premium will be by mutual consent or negotiation. Again, you don't know what they are. And what if you've had claims? What if the policyholder's had a lot of claims? The underwriter may decide he wants to really gouge the premium, and or say, well, this is in accordance with our rates and rules in effect at the time. Well, you don't know what it is. Do you really want to be exposed to that? How about we've seen language where, it's 1 year at 150% or 1 year at 75% of the premium. That's fine. But what about multi-years? And we've all seen policies as well that give you options to buy a 1-year tail, a 3-year tail, a 5-year tail. In certain types of policies, there's even unlimited tail coverage in the event of death of a lawyer or architect. We've seen those. These things are also used when companies are acquired, especially for D&O and EPLI purposes. It's important that tails be obtained because Company A is buying Company B. But in merger and acquisition situations, tails are an incomplete solution and actually can be kind of dangerous. And let me give you an example. Let's say Company A applies for coverage for itself or D&O, maybe even EPLI, maybe even professional liability if they're a professional service company like an big architectural firm or something. But nonetheless, let's say Company A submits an application to an underwriter and the underwriter loves the account. Great loss history. That looks like a very well run company. Gee, we really want to write this piece of business, et cetera, et cetera. And they're willing to honor the retro date and everything else. And then Company B comes along and it's the same thing. A nice company, well run, profitable, et cetera, et cetera, et cetera. And the underwriter says, gee, I really want to write this and I want that account. So why is it when Company A buys Company B, suddenly it's bad? And all of a sudden the underwriter says, well, we'll only pick up the prior act, any prior act after the date of the acquisition for Company B. We'll only schedule it to Company A's policy for wrongful acts that take place after the acquisition. The seller is going to have to buy tail. Well, that doesn't seem like a good idea to me. And furthermore, it is an incomplete solution anyways. First of all, if they can only buy 1 year's worth of tail, well, that's not going to be very good. Lawsuits can be filed long after that tail expires. The problem with multi-year tails, maybe the seller can buy a 5-year tail, for instance. Number one, it's expensive. Number two, you're taking one limit of liability, whatever that may be, and spreading it out over 5 years. So what happens when claims might take place and the limits are eroded, or the limits are gone because of settlements and expenses and defense costs? What happens then? Now there's no coverage available to the law. And even though there may be a contract between the buyer and seller that says, well, the seller's still legally responsible, good luck trying to collect. Good luck for the buyer tracking the seller down years later. And finally, of course, let's say nothing happens, and after 5 years the tail expires. Well, guess what? It's still possible for a claim to come out of nowhere that has wound its way through the courts and gone up on appeal and what have you, and finally it's final, and one of the defendants in that litigation says, okay, well, now I'm going to sue Company B. Well, the tail's expired. It's gone. So again, it's an incomplete solution. That solution is cured if an underwriter says, you know what, I like Company B, and we're going to schedule their retro date, and we're going to cover any wrongful act that took place subsequent to the retro date and charge premium for it, et cetera. But now you've got a complete solution because they've scheduled Company A's policy, and as long as Company A continues to renew their policy with that endorsed language with the carrier or carriers in the future, they never have to worry about the problem again. So what would that be worth to a buyer? And of course, maybe the seller might be willing to contribute to the initial premium for the first couple of years. But that's an option, and that's something to think about. In addition, there's one other thing to worry about, and this also is a true situation. The fact that the insurance companies agreed to pick up Company B as an additional named insured with a scheduled retro date, so it looks like they're covering any wrongful act that took place subsequent to Company B's original retro date, as opposed to, we're only picking up wrongful acts after they've been acquired. Don't forget, many of these policies do have a change in control or merger and acquisition clause, and that clause says we don't cover any claim arising from any wrongful act committed by the acquired company prior to the date of transaction. That's in complete contradiction to the endorsement we're talking about in picking up Company B as an additional named insured and scheduling their retro date to it. So the merger and acquisition clause and the change of control provision language of a policy must also be amended or endorsed so that it doesn't apply to the transaction where A bought B. Now you got a complete and smoothly worded policy form with little or no uncertainties as to that issue, and I can tell you this is a real case. It did happen, and the insurance company denied coverage based on the merger and acquisition language, change of control provision, even though they had agreed to add them as an additional named insured and agreed to schedule a retro date. You got to wonder why they even took that position. More gotchas. Prior and pending claim or litigation exclusions. Claims-made policies have gotten very, very complicated. First, to trigger the policy, the claim must be first made against the insured during the policy term. It must arise out of a wrongful act subsequent to the retro date. The claim must be reported to the company during the policy term. And now some E&O policies in particular are using what are called prior and pending litigation exclusions or continuity date exclusions, etc. One policy refers to the first inception date. So now you got to look at the definition of that. Or it may say that the insurer is not obligated to pay damages or claim expenses or defend any claim based upon arising out of directly or indirectly from any legal action. So in other words, you got a prior and pending litigation exclusion that uses absolute language, and here's the danger. Whether or not any insured was named as a party in such legal action. Wow. Let me walk you through that. A sues B. B sues C. C might even sue D. And finally, somebody sues the insured. Well, if any of that underlying litigation of A versus B, B versus C, etc., is prior or pending prior to the effective date of the policy, guess what? Under this language, the claim against the insured is not covered. And to me, that renders the whole policy illusory. I can't imagine how anybody can satisfy that requirement. It's crazy. And when I was a wholesale insurance broker, believe me, we wouldn't sell that policy if we couldn't get the underwriter to drop the language. I mean, I wouldn't even quote it. I mean, this is an incredible barrier to coverage. Another dangerous thing to concern yourself with, and now we're being a little bit more specific in general, but the definition sections, don't ever ignore those. I've seen an insurance policy that had separate definitions for wrongful act and an optional coverage. Don't assume that third-party discrimination coverage is always included in an EPLI policy. It is not. Sometimes it's optional, and you have to request it, and a box has to be checked off on the deck page to show that it's there. But nevertheless, in this particular policy, not only was it optional, there were two definitions, of course. One definition for the employment wrongful act, and another definition for the third-party wrongful act. Now, as you would expect to see in any EPLI policy, there's usually a bodily injury or property damage exclusion in the policy. And there's almost always a carve back that would say words to the effect that we don't cover any claim for bodily injury except emotional distress or mental anguish when associated with a wrongful act. In other words, an employment wrongful act. And I have no problem with that. They're carving back coverage for emotional distress. However, in this particular language, let's not forget, there are two definitions of wrongful act. There's a wrongful act, which deals with the employment practice, the standard employment practice items of wrongful termination and harassment, etc. And there's a separate definition for third-party wrongful act. Guess what? Third-party wrongful act is not mentioned in this carve-back. So in other words, this policy technically excludes any mental anguish or emotional distress arising from a third-party wrongful act. And I had to get it endorsed. How many people would have spotted that? That's a major gotcha. It is so subtle. Let me show you another language. In addition, a couple of carriers use an absolute bodily injury exclusion in their EPLI policy. In other words, they're taking out the carve back that exists in the exclusion we just saw. They're adding an absolute BI exclusion. As far as I'm concerned, it doesn't cover anything. How can you claim to be covering employment-related practices when you're excluding from coverage 80 or 90% of the damages? because almost all the damages claimed in any employment practice claim is for it's for emotional distress. So in other words, this policy only covers wages or, lost wages as a result of a wrongful termination, or, maybe Fair Labor Standard Act issues. But bottom line is it doesn't cover the majority of damages, and I really consider it a fraudulent policy. And I told that to the underwriter, I'm not selling this. Matter of fact, if you're going to use this exclusion, I'd prefer that you decline the account, because I am not going to sell a policy that only partially covers the hazard and does not live up to the reasonable expectation of the insured. Here's some more dangerous language that we've seen. EPLI and third party. Look at this definition. A current and former client or customer. Those are the only types of third parties that are covered. Wow. I've seen broader definitions of third party, meaning such words to the effect, anyone with whom the insured interacts. And I think that's a much broader language, but this one's limited to simply a current or former client or customer. So in other words, a Federal Express guy who may be harassed, whatever, they're not covered. And third-party claim brought by them would not be covered because they're not a former or current client or customer. That's pretty narrow. Look out for those. I mentioned earlier merger and acquisition, change of control conversions. Be careful with those. Often as well, the premiums can be fully earned upon the consummation of the deal. So a director and officer policy that costs hundreds of thousands of dollars, and then there's a merger. The premium automatically converts to runoff, and the premium is also fully earned at that point. We've actually had situations where the insured didn't want to lose their return premium and wanted to use it to credit as a credit towards tail or what have you. So we had to order the policy canceled literally the night before the transaction was to close in order to avoid this clause. Hammer clauses are another gotcha. We all know what they are. In essence, if the usually there's a consent to settle, and the insured says the insurer says we will not settle any claim without your consent. However, if you don't give us consent, you're on your own. From that point forward, we'll only pay that which we could have settled it for right now. We're not paying any more expenses. Hammer clauses have never been tested anywhere in the United States. And they've been around a long time, but they have not been tested anywhere. We've seen soft hammers, 50-50, where the insurance company says if you don't give us consent to sell, you're responsible for half of any additional settlement or judgment monies in excess of what we can settle it for, and they'll also pay 50% of expenses. It's possible to get that taken up to 70-30, maybe even 80-20. But be careful with hammer clauses and make sure your insured is aware of them. Diminishment limit forms, or defense in addition to limits. Well, what this means is diminishing limit forms are self-extinguishing. Is that, if you buy $1 million policy for D&O or EPLI, E&O, Cyber, these are usually diminishing limit policy forms. In other words, if there's a claim, any defense expenses, lawyer fees, etc., as expensed, as it's paid, reduce the limit of liability. So in other words, if you have $1 million limit and you pay attorneys $100,000, now you don't have a $1 million limit. You only have $900,000 to settle the claim. And the danger with these are the fact that what if the insured has multiple claims? What if the insured had multiple claims that are out of state? So you've got a defense lawyer in Illinois and a defense lawyer in California and maybe a defense lawyer in New York burning the limits of the policy with their fees, and they don't even know there's 2 other claims. These are very dangerous and requires really good coordination and communication between the insurance company claim department, the defense lawyers, and the insured. Defense in additional limits is something that is not always available, but I would highly recommend that you find out if it is. And that basically gives you an extra $1 million or $2 million, depending on the carrier and whether or not they'll even offer it, of defense expenses. It would be in addition to the limits of liability allocated for indemnity and for settlement and judgments. If you can't get defense in addition to limits, I highly recommend people consider limits in excess of $1 million, because I don't think $1 million is a lot anymore. especially in today's litigation world. And if it's a corporation of any size or a business of any size, they may have one or two claims. Then it becomes even more critical that they consider limits. Another problem we're seeing in many of these policies today, usually we saw in D&O, but and it's now coming into E&O policies, is the allocation of defense costs for covered and uncovered causes of action. Usually an insurance company, if they have to defend one cause of action, they have to defend them all, even though some of the things alleged may not be covered. Well, now they're trying to allocate that so that, if it costs $100,000 to defend all the causes of action, but only one of them or two of them are covered, they want to be able to negotiate how much the insured is going to have to reimburse the insurer for defending uncovered items. This can get really expensive, and of course the policyholder may not be too pleased either, and of course he's going to claim, well, gee, nobody told me that, I didn't understand it, my broker acted like I had good coverage. So here again is something to worry about. Now we have one that just takes the cake. I've never seen an exclusion like this, and it is out there. It is still being used. It is so on beyond zebra. It is amazing. And it's this one. The company shall have no obligation whatsoever under this policy to make any payment of any kind. And you can see it uses, absolute language for any claim for bodily injury or death, whether or not an employee of the insured, if benefits from the bodily injury or death are collectible or compensable under any workers' compensation law or any disability benefits law. Wow. Let me put this in the real world for you, because this is real. This actually happened. And I think may even be still alive. I'm not sure. An environmental liability engineer designs a pipeline to be used to carry oil in Florida. He's based in Texas. And he buys an environmental liability policy or environmental engineer's design policy that has this language in it. It's really kind of like a construction defect issue, because the pipeline was built using this guy's specifications. It exploded. People were injured and hurt. They sued the contractors under your typical construction defect theory, and they also sued him under a design theory that allegedly the pipeline may have been improperly designed. Turns out the engineer may not be the actual target, but he was just brought in just to cover all the bases. Nevertheless, 2 years into the litigation, after being defended by his insurer for 2 years, the insurance company learns that two of the plaintiffs are receiving workers' compensation payments from their employer under their employer's workers' comp, not the engineers. They weren't employed by the engineer. And they deny coverage. And they threaten to declare, they file a dec relief to determine the fact that they don't have coverage. And the sad part about this is the engineers in Texas, the loss happened in Florida. Both states follow what's called the four-corner rule, meaning that if the exclusion is clear and unambiguous, they're going to enforce it. So it looks like this exclusion is going to be enforced. The insurance company was convinced to stay their lawsuit until the case resolved. And if it looks like they could settle out the engineer for a nominal sum because he may not be the target here, then they were prepared to do it. But if it looked like the engineer would become the target, the insurance company said, we're going forward with this. And chances are they would win. So, point being, do you want your insured, or if you're the policyholder listening to this presentation, do you want to be the test case? If you're an insurance broker, do you want your customer to be the test case? I mean, this is kind of crazy. But this kind of goes back to what we were talking about at the very beginning of this presentation. Making a profit, uncertainty increases costs and expenses for everyone. Uncertainty increases unnecessary litigation. Uncertainty can turn one claim against the insured into 4 lawsuits, none of which were actuarially anticipated. And as a result, the insurance company can't possibly make money. Uncertainty resulting from the above can doom a program to failure, as the above is actuarially unsustainable. And that's not what we're all looking at, and that's not what we're hoping to achieve. We want an insurance program that is going to be profitable. We want an insurance company where everybody can make money. So let me give you the final summary and some takeaways. Where are the gotchas? They're in the insuring agreement. They can be tied to claim reporting provisions and claim reporting conditions, the definition of claim, and of course the extended reporting periods as to whether or not it's limited only when the company cancels or non-renews. If there is going to be an automatic grace period of any kind, it really should be referenced in the insuring agreement itself. And prior and pending exclusions need to be reviewed. The problem with a prior and pending exclusion of inception is that a lawsuit may be filed against the insured 3 weeks ago. The insured has not been served. The insured knows nothing about it. Policy renews today, and then the insured is served with that lawsuit 2 weeks from now. Under a prior and pending exclusion, they are not covered. Time bombs can exist with respect to the claim reporting conditions. So even though it's supposed to be a claims made and reported policy, there may be a time bomb that says you only got 30 days to report a claim once you know about it. Of course, we have absolute exclusions where you've got to worry about carve-backs referring to the insured or the wrongful act. The definition of insured, claim, potential claim, wrongful act, and professional services must be carefully reviewed, as well as the usage of carve-outs and carve-ins. Merger and acquisition and change and control provisions need to be reviewed, not only just from the standpoint of triggering a fully earned premium problem, but if you're going to have a situation where A acquires B, and B is going to become an additional named insured to A's policies, and retro dates are scheduled so they don't buy tail, you got to make sure that the merger and acquisition or change of control language is equally endorsed to refer to that transaction so that the condition, the M&A exclusionary language, does not apply to that transaction. We have to be careful of diminishing limits and making sure that you don't run into a situation where there isn't enough money to settle a claim because the attorney fees have eaten up the limits. And finally, you have to be careful with allocations between covered and non-covered items. These are some of the many gotchas that we need to be aware of in today's specialty lines world, and I hope that the listener has learned something from this presentation, and I look forward to hearing from you if you got any questions or concerns. Thank you very much.